All right, Ken, if you want to make your introductions.
I'll be happy to. On behalf of the El Monte South El Monte Chamber of Commerce, we welcome everybody to this session. Chris and I have worked very, very closely with the SBDC, Don Lowell, throughout the pandemic, trying to get the word out on what's available in terms of grants and EIDL loans and all of that. And I think we have been very instrumental in surviving a lot of businesses out there that, that would not, be here today. We have over 400 members. A lot of those members, probably at least 300 are below 20 employees or less. And the stamina and the blood, sweat, and tears that these business owners go through just to keep their doors open, through this. And now we're going to be talking about, labor laws and what's happened in the state of California in terms of what they are going to be exposed to is priceless. It's invaluable. And I couldn't thank the SBDC enough to host this. And if you want to just turn it over to self-introductions, I'll pass the baton.
Thank you, Ken, so much for the introduction and for having us here today. Welcome, everybody. My name is Xiomara Palma. I am the founder and CEO of Solvit HR. I'm also an advisor here with the SBDC, and it's a pleasure to be here with you all this morning to give you a brief update on 2023 employment laws for small businesses, in particular for small businesses. Before we get started, I would like to introduce the SBDC for those folks who may not be familiar with who we are and what we do. We have a short video we'd like to play to introduce the SBDC. So I will hand that off to Annie.
Our mission is simple: to help businesses grow and succeed. At the SBDC, we offer no-cost consulting and low-cost training to make it easier for businesses to start, grow, and recover. As a valued resource partner of the SBA, the SBDC serves small business owners throughout the U.S. by providing timely expertise and advice that business owners can use today. These services are especially helpful for small businesses impacted by COVID-19. There are 9 SBDC locations in LA and Ventura counties, and one right here in Pasadena at Pasadena City College, where we offer one-to-one consulting with experts in SBA disaster loans, strategic planning, marketing, financial analysis, and many more vital services. For no-cost help with your small business, contact the PCC SBDC at 626-585-3105, SBDC at pasadena.edu, or pccsbdc.org. We are here to help, no cost and no catch.
Thank you, Annie, for playing that video for us to introduce the SBDC.
No problem.
Now let's get started with our topic today, 2023 new employment laws for small businesses. Keep in mind that these are not all the laws that went through in California this year, but these are the most relevant impacting small businesses. I will be checking in with Annie throughout the presentation to see if anyone has any questions on the materials we do cover. So feel free to drop any questions you have in the chat. Annie's going to be monitoring that. Otherwise, we will have a Q&A session at the end. So with that, let's get right started. A little background on myself. I've been in human resources for over 15 years now. I am the founder and CEO of Solvit HR, a consulting firm that helps mostly small businesses with employer compliance and anything related to managing employees. Also an advisor here with the SBDC and a resource to any business that needs any assistance managing employees or learning about compliance requirements for employers. Again, We encourage you to schedule an appointment should you need any assistance with either myself or one of our other experts, depending on what you may need. We have quite a large team of experts, about 20 teams of experts here to support small businesses. So simply reach out to sbdc@pasadena.edu to schedule a free consultation. What we're going to cover today, a few areas I would like to concentrate on in terms of new employment laws that went through this year. We're going to talk about wage and hour laws impacting small businesses. We're also going to cover laws related to benefits for employees, workplace safety, and a few other miscellaneous laws that do apply to small businesses as well. And again, we will have a Q&A session at the end, but I will also be checking in with Annie throughout the presentation because I know sometimes questions do come up in regards to the materials we do cover. A brief disclaimer before we move on to the presentation is that, as many of you know, human resources is an ever-evolving area, and the topics I will cover today, the update I will provide today, is current as of today, February 24th, 2023. The materials are not to be interpreted or misconstrued as legal advice or recommendation. Rather, they're for informational purposes and for best employment practices in regards to human resources management. All right, let's dive right in. First law is in regards to pay transparency requirements for small employers. We have SB 1162 that went into effect January 1st of this year. And this law has a few layers that apply to small employers at different levels. So some requirements that apply to all employers, regardless of size, are that employers are now required to provide the pay scale to current employees for their current position upon an employee's request. All employers are also required to maintain records relative to job titles and wage history for each employee, not only for the duration of their employment with your company, but also an additional 3 years after separation of employment. So that's a key area to maintain your records. And one thing that a lot of smaller employers forget to do is, for example, when they are transferring or switching payroll companies, they forget to get that information from their previous payroll provider. So that is something to look for if you are looking to switch payroll companies, or if you in the future will be switching payroll companies, to also make sure that you retain and request those records going back in time so you are in compliance. The law does have a rebuttable presumption in favor of the employee. And what that means is that if an employee should file a claim against you for failure to provide a pay scale or failure to be in compliance with this requirement, the labor commissioner or a judge may automatically rule in their favor if you are not in compliance with keeping the records. So a lot of labor laws do have this rebuttable presumption. It is the employer's responsibility to maintain records, even for any small transactions you do in the employment relationship. Now, the second layer of the law is for employers with 15 or more employees. I think this is the one that everybody is the most familiar with. It's in regards to providing the pay scale on job postings or job ads, and also to employees upon request. And if employers do engage a third party to post their jobs, such as a recruiting agency to recruit for their employees, they must provide this pay scale to that third party to be in compliance. One question that does come up a lot in regards to this law is the employee count. Some businesses wonder if it includes all employees, if it's just the full-time employees, or if it is just the part-time employees. But the employee count is defined as any pay period where an employer reaches 15 employees. So that it's technically all employees you would have in your payroll system. One exception or one exemption of the law is that it does not require employers to disclose bonuses, commissions, or any other tangible benefits you may provide for the job. And penalties can range from $100 to up to $10,000 for noncompliance for each claim in the law. Now, the third layer of the law applies to larger employers, those with 100 or more employees. And this is an amendment to a previous law that went through back in 2021 that require employers with 100 or more employees to submit pay data to the Department of Fair Employment and Housing, now known as the California Civil Rights Department. They've changed their name last summer. And it required employers to provide this information due by March 31st. And it basically aligned with the federal requirement of the same size employers. And the federal requirement requires a report, it's called the EEO-1 report, to be submitted. So a lot of employers were able to satisfy the California requirement by also submitting a copy of their EEO-1 report to the DFEH. But now that requirement will change. It no longer satisfy the requirements here in California because this law amended what's required of pay information. So now it includes that employers have to include the mean and a median for each job category broken down by race, ethnicity, and sex. So because of this new requirement, the EEO-1 no longer satisfy the requirements here in California. So employers need to generate a new report in order to satisfy this requirement. And in addition to that, if employers have multiple locations, they now are required to provide a separate report for each location they may have. And with the new year, we always see an increase to the state's minimum wage. This year is no exception. We currently have a minimum wage of $15.50 per hour for all employers. And that is a significant jump for the smaller employers, those with 25 or less employees, who were required to pay $14.50. They were trailing the larger employers by 50 cents. Larger employers being those with 26 or more employees were already required to pay $15 per hour as the minimum wage. So that is a dollar jump for the smaller employers. And it has to do with the increase in the cost of living and the inflation rate that we saw last year as well. One thing to keep in mind when minimum wage increases, if you have any salary employees, the minimum salary also increases because California requires smaller employers to, not small employers, but all employers to pay their employees double the state's minimum wage to classify them as salaried employees and being exempt from most of the wage and hour laws that apply to hourly employees. So the current minimum salary you could pay someone as an exempt employee would be $64,480. And there's also a minimum monthly salary that you have to meet, currently being $5,373.33 in order to comply with that law. One thing to keep in mind is that in order to satisfy the requirement of classifying someone as salary exempt, there are several requirements that need to be met. One of them being paying them the minimum salary for the year, but also making sure that they meet or their job duties fall within the categories that allow for employers to classify their employees as salaried employees. So there is a minimum salary test, and there's also what's known as the duties test, which falls under different categories that the state allows for employees to be classified as exempt from overtime. In addition to the state's minimum wage, we have also local city ordinances that require employers to pay their employees the city's minimum wage if an employee performs work within the geographic boundaries of the city. Here in Southern California, we have the cities of Malibu, West Hollywood, Los Angeles, Pasadena, Santa Monica, and unincorporated LA County that have their own city ordinances to pay employees a minimum wage that is actually higher than the state's minimum wage. So if you have an employee that performs at least, generally speaking, most of the ordinances require at least that they perform 2 hours of work within a work week in order to pay them the applicable minimum wage within their geographic boundaries. There are exceptions for some of the ordinances. They have a lot of similarities, but there are also differences. So if you do have employees that perform work within those cities, I encourage you to review the requirements from each city or reach out and we can review those together. I would like to check in with Annie right now to see if we have any questions in the chat.
Hi, Xiomara. So question regarding the minimum wage. Does it apply to part-time employees?
Yes. The minimum wage or minimum salary?
The minimum salary.
The minimum salary does not apply to part-time employees. Part-time employees are not able to be classified as exempt or as salaried because their hours may fluctuate, right? If you have somebody that's part-time, they may work 20 hours a week, they may work 15 hours a week, they may work 30, 39 hours a week, and they may work more. So because of that fluctuation, the state does not allow for part-time employees to be classified as salaried because it's not a consistent work schedule for them. So only full-time employees can be classified as salary exempt employees.
Okay, great. And the local ordinances minimum wage does apply to part-time.
Yes.
Okay, great.
That's fine.
Thank you.
You're welcome. All right, so another area that's highly contested, and this is the area actually that is the most contested in wage and hour employment laws, is the meal and rest periods requirements for employers. So California requires that an employee be provided an uninterrupted 30-minute meal period for every 5 hours worked during their shift. A lot of employers don't realize that the requirement, this meal period needs to be provided to them before the end of the 5th hour. There is a misconception that it has to be done by the 5th hour, but that is already in non-compliance. So an employee is in compliance if they take this meal period once they have worked 4 hours and 59 minutes or less. During that time, they should be able to take their meal period. We did have a few lawsuits last year because every other year there is a lawsuit that contests this area of wage and hour requirements. So we did have a few lawsuits last year. There was a lawsuit where an employee was fired, of course, and upon being fired, he submitted a lawsuit to the employer alleging that he was not being paid for meal periods, or he was not being paid for missed meal periods, and the employer had not paid them their premium pay as is required. When an employee misses a meal period, because they were not able to be relieved from their job duties, they were required to continue to work due to work demands, then the employer owes them a 1 hour premium, used to be called a penalty, but 1 hour premium at the base rate of pay. That's what it used to be. But this new law actually, or this new case, redefined that requirement, and it actually turned the penalty into premium pay, because it alleged that in order to be premium pay, it needed to be classified also as a wage. So now employers are required to pay employees for this premium pay at the regular rate of pay, which is different than the base rate, an employee's base rate. So an employee's base rate would be, if you hire someone at minimum wage, $15.50 an hour, that would be their base rate. But if you are compensating someone 50 an hour, and then in addition to that, you give them bonuses and you give them commission, then now you have to calculate a new rate of pay, taking into consideration all the compensation you provided to them within that pay period. And then you would divide it by the hours that they work to come up with the new rate. And upon that rate, that's what you would use to pay them for the extra hour. So that's what changed last year, is the rate that it is to be calculated. And it also, there was also a lawsuit that alleged to had to do with rounding, or clocking in, clocking out, and rounding of meal periods. So there was an employer that, upon an employee clocking back in, if they clocked in 28 minutes after they had clocked out for lunch, their payroll system would automatically round up to 30 minutes. So that was found to be in violation of the law. So make sure that if you do have a payroll system that does any kind of rounding, you want to make sure that you disable that feature in that payroll system, because it's found to be not in compliance with the requirements of California. And in fact, it has been found not to be in compliance with either clocking in for the day or clocking out for the day. So definitely there's no rounding as a best practice that should be practiced within your organization. So you gotta pay employees up to the minute on what it takes them to complete the work. And also accurate records need to be reported and maintained by the employer, and you're required to maintain payroll records up to 4 years. On the benefits side of the employment laws, we did see a few laws that went through, one of them being protected bereavement time. And now employers with at least 5 or more employees are required to provide unpaid bereavement time to their employees if an employee has worked at least a minimum of 30 days for the employer. And the qualifying family members for which an employee can take bereavement time include spouse, child, parent, sibling, grandparent, grandchild, domestic partner, and parent-in-law. That really aligns with the same family members under other leave laws. The employee has up to 3 months to be able to take the bereavement days. And again, it's unpaid time unless you, the employer, provide for paid time. Most employers provide up to 3 days of bereavement time. So if you do provide the 3 days, there would be an additional 2 days that the employee can take unpaid. However, the law does provide that the employee can tap into any available time that they may have, such as vacation, paid time off, or sick time, to be able to be compensated for the time that you, the employer, do not compensate. There is a protection also for the employee from discrimination, interference of, and retaliation because they are requesting the time or taking the time. So that is protected. And the days do not have to be consecutive. Again, they do have 3 months to be able to take the days, but they do not have to be consecutive. And employers are allowed to verify and request documentation to verify the need for an employee's bereavement time, but those records must be maintained in strict confidentiality. Now, what that means is that essentially only the person or the custodian of records should be able to have access to that information, and you probably should keep that in a locked cabinet. Or, if I know that cabinets are pretty outdated nowadays, we maintain a lot of electronic records, so making sure that only the people that administer the business or need to know have access to that information, and that they maintain confidentiality as well. We also did see an expansion to the definition of qualifying family members under the California Family Rights Act, and also under the Healthy Workplaces, Healthy Families Act, aka known as the Paid Sick Leave Act. So now, in addition to the family members, we saw the same family members under bereavement time. Now we did see an expansion include a designated person. And there is a difference between the two definitions under each law. So for the California Family Rights Act, is defined as any individual related by blood or whose affiliation with the employee is the equivalent of a family relationship. So that could be their cousin, that could be their uncle, that could be any family member. And then under the paid sick leave law, we see it as a person identified by the employee at the time the employee requests sick days. So that's a little bit broader than the one under California Family Rights Act. Employers do have the right to request that only one, or restricted to only one designated person per 12-month period. And that 12-month period should really align with how you calculate leave time or how you administer leave of absences for your employees for California Family Rights Act. So there are several methods you can use to calculate that 12-month period. So it could be a calendar year, or it could be from the date the employee requests the time off, or it could be from that date looking back 12 months. So just making sure that you are consistent with that method that you are using to limit that designated person to one per 12-month calendar year or 12-month period. We also did see an expansion to CalSavers as well. For those of you who are not familiar with CalSavers, I hope everyone is, but for those of you who may not be familiar with CalSavers, is essentially the state's retirement program. And this law went through, I believe was in 2020, and it was phased in depending on the size of employer. Employers are required to register with CalSavers, and essentially it's a savings plan or retirement plan for the employees. So what an employer has to do is just basically coordinate or facilitate the deductions from the employee's paycheck and remit those to CalSavers on behalf of the employees. The employees can choose to opt out as well. And if an employer already provides their own retirement plan, they don't have to do the deductions, but they still have to register with CalSavers to let them know that they already are in compliance, because they do provide a retirement plan as well. That trickle down to employers with 5 or more employees, and they were required to register by June 30th of last year, was the last deadline for them. There are penalties for not registering with CalSavers, which can be $250 per employee as imposed by the Franchise Tax Board. And there can be an additional $500 per employee penalty if the Franchise Tax Board sends you a notice and you fail to register within 90 days of that notice. So essentially you're looking at potentially $750 per employee for failing to register. Now, what the law did this year, SB 1126, is that it expanded the requirement for employers to register to those with at least more. So that excludes business owners, but you must register, and you do have until December 31st of 2025 to comply and register. And again, if you already provide a retirement plan, then there's not really much you need to do other than let them know that you already do have a plan. But this is a requirement, and definitely not something you want to incur penalties for. A few other changes in regards to benefits, and these are benefits as provided by the state of California under the Employment Development Department, or EDD, as many of you may know it. There is an increase in the wage replacement benefits rate that employees would be paid when they either go on state disability insurance or they tap into paid family leave as such in situations with baby bonding time or to take care of a qualifying family member. Employees currently get up to 65 to 70% of their wages for wage replacement when they go on disability or when they go on paid family leave. So this law would increase the benefits significantly up to 90% of the employee's wages by January 1 of 2025. Now, there are some grants that the state is issuing too for small business owners to be able to offset the costs that they may have when someone qualifies or since someone goes on disability or goes on family leave. There are some grants. So employers with 1 to 50 employees may be eligible for up to $2,000 for a grant, and employees with 51 to 100 employees may be eligible for up to $1,000. And these are the employee count actually is for employees that are here in the state of California. You know, sometimes people have questions because they have employees out of state, but this is for people that would be able for benefit under the state of California. So that's the whole purpose there. There are some eligibility requirements that need to be met. For example, employers will need to employ between 1 to 100 employees, be registered to do business in the state of California, be in an active status with the Office of the California Secretary of State, and have an active California employer account number under which employees are listed for payroll. So this would be like the number under EDD that you're required to maintain to remit payroll taxes. The application deadline is May 31st of 2024 or until funds run out. And I can tell you as of now that there is a waiting list already to be able to get one of the grants. Businesses that do have a PEO, that stands for Professional Employer Organization. So these are, for example, like the ADPs of the world or the Paychecks of the world that may take care of your HR, your payroll, your workers' comp or safety. If you do have a PEO model with a third party, you are not eligible to qualify for a grant because that is considered a co-employment relationship between the PEO and you. And so you would not be eligible for a grant if you do have this, you do business with a PEO. Now, check back in with you, Annie, to see if we have any questions in the chat.
Thanks, Xiomara. So far, no questions in the chat.
Great. All right, so now moving on to workplace safety. We did see a few laws that went through in regards to mostly related to COVID-19, but we did see a few laws that went through in order to preserve and maintain an employee's safety and right to exercise and ensure their safety in the workplace. We had SB 1044 that prohibits employers from threatening or taking adverse action against an employee for refusing to report to work or for leaving the workplace if the employee believes that there is a reasonable belief that the workplace is unsafe. Employers are not allowed to prohibit workers also from using their mobile device or a communication device to get emergency assistance or assess the situation or to communicate with someone to verify their safety. So this is something, if you do have an employee handbook, that you will need to update your cell phone use or your telephone use policies to make sure that you're not in violation of requiring an employee not to be able to access their mobile device during work hours. And employees are required to notify the employer in advance, if feasible, that they either will not be reporting or will be leaving the workplace, but if not feasible, they're required to do so as soon as possible. Now, emergency condition as defined under the law is conditions of disaster or extreme peril to the safety of the persons or property at the workplace caused by natural forces or a criminal act, or in order to evacuate a workplace, worksite, worker's home, or the school of a worker's child due to natural forces or a criminal act. So something that comes to mind would be, for example, an active shooter situation, right? So that definitely would be something that falls under this law that is protected. Now, I was glad to hear that a pandemic, the law specifically says that a pandemic is not considered an emergency condition under the law. Otherwise, we would not have workers proudly reporting to the workplace when you have positive COVID-19 cases in the workplace. There are a few exemptions of the law, mainly in the healthcare industry, and also some disaster service workers are exempt, among others. So it's something to keep in mind too. If you're in the healthcare industry, there could be some exemptions there. Now, on the COVID-19 front, we did see an update actually to an already existing law. So back in 2020, there were notice requirements, or there was a law that was passed that require employers to notify their employees within 1 day of knowing of a COVID-19 case, and providing them written notice of the exposure of that case. And that has been in place and was set to expire as of January 1st of this year. But this law, AB 2693, actually extends it another year. However, it makes a few changes to that notice requirement. Now, employers can satisfy the requirement of a notice by posting it the same way they would post employer postings or notices to employees. You still require, though, employers are still required to include the dates of the infectious period when the positive COVID-19 case was on site. And one good thing is that it no longer requires employers to report COVID-19 cases to their local health department. And again, the notice is in effect. This requirement is in effect until January 1st of 2024. Another update that we did see in regards to COVID-19 requirements is that Cal OSHA changed their emergency temporary standard to a non-emergency temporary standard. And that went into effect recently, February 3rd of this year, and it's in effect until February 3rd of 2025, unless they decide to extend that requirement at some point. But previous to this effective date, we had the emergency temporary standard, or ETS, that had been put in place since November of 2020. And it essentially required employers to create a COVID-19 prevention plan and maintain protocols and policies that they would have their employees practice in order to prevent the spread of COVID-19 in the workplace and ensure their worker safety. There were several amendments that were made to the requirements that needed to be covered under the COVID-19 prevention plan. So there were 3 amendments that were made, and that was set to expire as well end of last year. However, Cal OSHA decided to make it or roll it into the already required injury and illness prevention plan that all employers are required to have. So all employers need to have an IIPP that essentially ensures the safety of their workers in the workplace. And there are several sections that are required to be covered in that IIPP. So now they're rolling this non-emergency temporary standard into the IIPP. Employers are no longer required to have a separate plan for COVID-19. If you do have it, you can keep it, that's fine. But now you can also just comply with the requirements by rolling it into the IIPP. So it replaces the original requirements. And one of the positive things is that it actually now aligns with the requirements of the California Department of Public Health. Previously, we had several different requirements that we needed to satisfy. So Cal OSHA had their own requirements. The CDPH had their own requirements. State of California had their own requirements, and a lot of times contradicted themselves. So this is like a wonderful update that they made to the standard to harmonize with the CDPH and its requirements. Employers are still required, though, to report major outbreaks to Cal OSHA, and also employee death and serious illness as it always has been a requirement. So some of the changes you may see with this non-emergency plan is that exclusion pay has been removed from the requirements. So With the original ETS, employers were required to still compensate their employees or provide them exclusion pay when the worker was exposed or when it was a positive case. They needed to be excluded from the workplace, and also the employer needed to provide them exclusion pay for the time that they were out. Now, this non-emergency standard eliminates that requirement of still having to compensate the workers. And I know that that was such a big burden, especially for small businesses trying to operate during COVID and post-COVID, trying to recover and still trying to find ways to compensate their workers while they were not in the workplace and dealing with COVID-19. So that's great news. COVID-19 testing in the workplace still needs to be provided to workers if they are exposed, and it needs to be done during work hours for those that are close contact in the workplace. And again, the COVID-19 prevention plan is no longer a requirement for it to be a standalone document. Rather, you can roll it into the IIPP, but if that's too much trouble, you can still keep the COVID-19 prevention plan to satisfy the requirements from Cal OSHA. Some of the things that are not changing are you're still required to investigate COVID-19 cases in the workplace. You still gotta include the dates of a positive test and the symptoms. Must maintain effective policies and protocols to prevent the spread of COVID-19 and protect your workers. And the definition of a close contact is not changing. And I'm knocking on wood and thanking my lucky stars, because this had created a lot of confusion in the past for employers, but now we're keeping the same definition. And that is a close contact is considered a close contact if they're sharing the same indoor space for places with less than 400,000 cubic square feet. And it's 6 feet of distancing as it originally was for those places that are larger than 400,000 cubic square feet. So that's still the definition of close contact. Again, free testing needs to be available to close contacts in the workplace, and you know, that's not changing. It's not changing the requirements there. We also did see a few laws that went through related to discrimination in the workplace. AB 2188, this is going to be effective January 1, 2024, but essentially provides protections for employees and applicants based on their use of marijuana off the job and away from the workplace. So an employer cannot discriminate against someone or against an applicant because their test results, drug test results may have come back positive for marijuana or for them using it recreationally. And the employer applicant may not possess or be impaired or use marijuana while on the job, so that the employer still has the right, if an employee or an applicant engages in violating an employer's drug use policy, that is still protected and the employer still has the right to enforce that. SB 523, that's effective this year. That amends the California discrimination laws in regards to protected categories. So these are, for example, all the categories such as race, gender, age, sexual orientation, those things. So this law adds a new protected category, and that protected category is for reproductive health decision-making. So an employer cannot discriminate against an employee or applicant based on their reproductive health decision-making. So this is a new protected category for employers to keep in mind when hiring or any transaction in the workplace during the employment relationship, as well as the same with the already existing categories. So with that wraps up my update. I do have a few things I'd like to point out. We do have every Wednesday a small biz talk show or webinar that is conducted by our financial guru Lori Williams every Wednesday at 10 a.m. So I encourage businesses, so small employers or businesses, to check that out when you get a chance. And she does have quite a myriad of topics that pertain to all small businesses that are relevant, that a lot of you probably can take advantage of. And also we do have an Instagram account as well. If you'd like to follow us, our address is at Pasadena SBDC, where we actually do post a lot of updates on upcoming events and just updates on happenings with the Small Business Development Center. So with that, I will check back in with Annie to see if we have any questions.
Hi, Xiomara. So far, we don't have any questions. We can give the audience a few minutes if they have any questions that they want to put into the chat. There is something I'd like to share with everyone. And I'm going to put the link in the chat first. And it's regarding a new grant that's currently out. It's the Economic Opportunity Grant for Los Angeles County small businesses. The link is in the chat right now. You can go to this. I'm going to share my screen, Xiomara.
Sure.
Let's see.
I just clicked the link to see if we can, for everyone to see.
Okay. All right. Do you see that? This is the Department of Economic Opportunity. This is the information for the Economic Opportunity Grant Program. Our network, the LASBDC network, they are coordinating this. This is also going to be applied through Lendistry. But if you are a small business, we're currently in phase 2, just started yesterday, all the way through May 20th, or until funding is out. And this provides grants of up to $15,000 for micro businesses under $100,000 in revenue in either 2019, 2020, or 2021 taxable years. And then we are still in phase 1 as well, which started about a month ago, still ongoing. And this is for micro businesses. These are smaller grants of $2,500. For those with a revenue of under $50,000. So I do encourage you, if you're looking for grants, if you've been impacted by COVID-19 and are still working on, trying to gain your footing, through the pandemic, I encourage you to go here, eog.smallbizla.org. There is an apply now. You can get application help. This is actually a very useful website because I'm going to show you. So right now, if you go to the Get Help button, there are multiple ways for you to get information on the program. They are holding info sessions. There's, let me go to that right now. See, okay, it's over here. So if you want to attend an informational webinar, you can sign up. Let's see here. Yeah, so they have different info sessions. So we're right here. They have daily office hours right now. So if you go into the calendar, they're holding daily office hours, answering any questions that you have about the EOG. Actually, let me provide you another link. Let's see here. And I'll put that other link in the chat because that shows you all the different live info sessions they're going to have, all the open office hours. So they also have how-to video tutorials in multiple languages. So they have it, of course, in English. They also have it in Spanish and all these different languages as well. So, if you're applying and you need additional information, they try to break it down. For example, if you need one in, traditional Chinese, it breaks it down on how to apply for this grant. So, okay, let's see. So Ken, you have a comment you want to make? I'll stop sharing.
Yes, Annie. Again, I thank you and the SBDC for this very informative webinar. We've been as a chamber involved in retention of businesses within the state of California. And I've counted 9 different assembly bills and Senate bills that have been mentioned. What is your take on retention of businesses not leaving the state of California or Southern California?
This is from an HR standpoint, something that Xiomara can answer, or just in general, as far as like us as SBDC working with small businesses?
Just in general, because I think that, you know, when we talk to our members, and we got a lot of big members, and you know, they're frustrated with the bills, if you will, you know, in the state of California that have them looking outside the state or outside of the county. You know, we get this question all the time, Chris and I do, that, you know, gee whiz, you know, why shouldn't I go to, you know, Texas or Nevada or something like that? So, you know, it was just a comment, because after you went through 9 different bills, you know, that, you know, I mean, are these bills similar in other states, or is this a California issue, or just a comment? That's all.
I can tell you, Ken, from an HR stance, this is actually something I hear a lot too from my own clients and working in human resources, because the laws are so stringent and so pro-employee here. A lot of employers do feel frustrated having to do business here in California and comply with so many requirements that now it feels like they are held to the same standards as a large corporation, right, with 1,000+ employees, with all these laws trickling all the way down, even to them having just one employee. Now people are hesitant to actually hire employees and be able to comply with all the laws because of all the responsibility and liability that comes with doing business or conducting those employment relationships and transactions in the state of California. There's just a lot of exposure there. In terms of, you know, just in general, outside of HR, I think that really the goal of the SBDC is to make sure that all the resources are provided to businesses in terms of grants and things like that, so that they are able to maneuver through like the requirements they do have through the state. I know that there is a lot of frustration there, because I do get that a lot from my clients. They're like, I'm moving to Arizona, I'm moving to Texas, I'm going to do business elsewhere. But we are here as a resource and a lifeline really for any businesses to reach out for resources we do have available, you know, such as the grants that come through, things like that, that can support businesses to be able to best maneuver and find different ways to comply with these laws. So again, reach out to us and we're able to pair you up with our team of experts. Like I said, we do have a team of about 20 advisors at the Pasadena SBDC, but we do have a larger network here in Los Angeles. If there is like an expertise or a need for someone that is not in line with the expert at the Pasadena SBDC, we can definitely refer them to one of our other locations to ensure that businesses do get the support and help that they need to continue to thrive.
Yeah, in my opening comments, I mentioned that because one of the biggest challenges for Chris and I is to get the word out, because people don't, and the businesses don't understand what's available, you know, out there through the SBDC, and you know, you know, we hear the frustration about doing business in California, and we represent some big companies, no doubt about it. But
Yeah.
you know, our challenge as we learned through COVID is to get the word out.
Yes.
Get the word out. This is what's available, PPP, whatever it is. I mean, you know, and that's our biggest challenge. And the purpose of this webinar today was to get the word out. I mean, you mentioned, 9 different bills. I mean, holy smokes. That's a lot of that's a lot of stuff. That's a lot of stuff without, just running your business.
Yeah, and actually this year is one of the years when we didn't see a lot of laws go through as previous years. So again, I mean, we are here as a resource, and I do agree with you that's the hard part for people to find the resources, the funding, the grants, and all the resources they can tap to so that they can continue to run their businesses like a well-oiled machine. So we're here to help. I encourage everybody to follow us on Instagram. We do have a lot of information that we do share there. And also you can link up with other organizations through the SBDC that we do have as our contacts there as well. But again, don't be a stranger, reach out. We're here to help. If we, like I said, if we don't have the expertise, we are going to find someone that is going to be able to help you. And the great thing is that it's all at no cost, right? It's all free.
Exactly.
Yeah, I couldn't have said it better, Xiomara. And, just to add to that, like the EOG, I think the state of California is doing a lot as far as trying to provide resources to small businesses. The PPP and the EIDL, they were, provided on a federal level. Those who weren't able to tap into that, California is trying to make up for that. So again, if you are in need of that, the state of California is providing a lot of resources and grants. So definitely stay in touch with your local SBDC, because we're always sharing information on the newest information, the newest grants. And so, we want you to be able to, tap into all those resources to keep your business going. And again, like Xiomara said, we have, amazing group of team members. We have like 21 advisors right now who are here to help you. It's absolutely at no cost. So definitely reach out, even just to send us an email if you have any questions.
Absolutely. Well, thank you everybody for joining us today. It's been a pleasure to be here, and we look forward to connecting with you all either electronically or on one-on-one consultations. Thank you very much, Chris and Ken, for hosting us. And
thank you.
I wish everybody a nice weekend, and hopefully we see you soon. Take
Bye-bye.
care.
Stay dry.
Bye-bye.
Thank you.
Bye.
We'll see you. Thank you.